Freya, I'm just checking to see if you can hear me.
Hope so. The Wi-Fi here.
Oh, are we having a problem?
I think I got it though.
Yeah. Which group of cases it is and where they are on the docket.
I think there's only that case.
Oh, so it's the only case there is.
Well, group.
That's what I meant.
Yes, there's only one.
Okay.
So these guys.
And do me a favor, why don't you use the restroom? And find out how old is the oldest case.
Okay.
Yeah. He just retired from Marcus. So he's the small. Actually, that's it's okay. That's the case. Depends your way to get the degree and not have to do the work. I talked to that. Figure that out. Yeah, I sometimes participate in. Yeah. Same. Sometimes let's see. Yeah.
All right, good morning. It is 9 a.m. Today is Thursday, April 16. This is a regularly scheduled status conference docket for the Oil Conservation Division. I see Ms. Bennett and Ms. Hardy here, and I'm going to call a case that's not on our docket first because you're both here. And this is, of course, 25878, the case that we dealt with yesterday. We received a motion, an expedited motion from Ms. Hardy on behalf of PBEX, et cetera. And we spoke to Ms. Bennett regarding Chevron's response. And I know, Ms. Hardy, that you were hoping for an expedited decision, and I know why. And Ms. Bennett, you said that you had received that motion and that you were prepared to respond within 1 week, which is the 22nd of April. And the hearing is May 13. Is that right? That is May 13. Freya, where is that hearing on our trailing docket?
I believe it's like number 3 at this point.
Okay. And what are the other two?
I need to pull up that docket. 1 second. We have number 1, Tap Rock operating. And then Powderhorn operating, and then Select Water Solutions. So Chevron's actually 4.
Okay. And Ms. Hardy, and then I'll ask you, Ms. Bennett, are you involved in any of those other cases? You are. Which case are you involved with?
The Powderhorn case and the Select
Oh,
case.
right. I knew Select was yours.
And Ms. Bennett is also involved in the Select case.
And the Select case was one of 4, wasn't it?
Yes.
The other 3 were heard by affidavit and they're in the process of
Correct.
whatever it may be.
Right.
And is there any reason you think that that won't go that day?
No, I don't. We're planning to proceed that day.
I know that the parties who were not permitted to intervene appealed to the commission. Were
We
you
did.
involved in that?
Yes, and that is pending. The commission said there will be further briefing, and I think the commission's plan was to hear that at the end of May. Hear argument at the end of May.
So most likely the case will have been heard by then
Right.
and be taken under advisement by
Right.
then. Okay. And Ms. Bennett, you're involved in that Select case, you said?
I am. I have been in discussions, or at least I've floated the idea by Ms. Hardy that given the pendency of the commission proceeding, whether it would make sense to delay the Select Coyote case, because I know Select doesn't agree with me on this, but given the outcome of the commission proceeding, that could impact whether the parties should be involved in the Coyote case. And I know that ship has sailed for the other 3 cases, but it hasn't yet sailed for the Coyote case. So I indicated to Ms. Hardy that I am thinking of that through. I don't know that that's going to come to fruition for a couple of reasons. But at the moment, it does appear that that case will move forward.
And if I have anything to do with it, that case will move forward. So just telegraphing my thought process here. I mean, the rules are very clear that you can appeal to the commission after a final order is issued by the division, and those parties have decided. And we have Mr. Swazo here, and he's representing Pilot, and I know he hopes differently, but we'll see what happens. But no, I want to get that case out of the way. And you said Powderhorn was yours?
Yes.
And did you say Tap Rock was yours?
Tap Rock is not.
Okay, but Powderhorn is.
Yes.
And who's opposing Powderhorn?
MRC has filed competing applications, I believe. To the
Who's
Powderhorn
representing
case.
MRC?
Holland and Hart, I believe.
Okay, do we have anyone from Holland and Hart today?
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian.
Thank you, Ms. Vance. I suspect negotiations are ongoing. I'll ask you, Ms. Vance, in just a moment. Ms. Hardy, how are negotiations going?
I know that they are ongoing, but it's my understanding there are a lot of moving parts to these applications and different spacing units. Some overlap, some don't. So I don't know at this point what the odds are on it getting resolved.
And that's, of course, that's really you understand. Ms. Vance, to you?
And just so I understand, because I wasn't prepared for
You would
to discuss these. This is the 25888 case. Is that correct? The Quail Dobbs?
I don't know. Let's find out from Ms. Hardy.
That's correct.
Yes, Ms. Vance.
Okay. I believe if I don't want to speak out of turn, but I believe that Matador is going to be sending out their own proposals or have already. I would have to look at my email communications to confirm that, but my understanding is that this will go to a contested hearing.
Okay. All right. Okay. I know I'm putting you on the spot. I know that you weren't. I know you weren't prepared. I'm just trying to figure out the Chevron case really here. Okay, and it's number 4 on the docket. And Freya, you said Taprock is the second or the first case? I lost you.
It's number 1.
It is number 1. And who's representing Taprock?
I am.
Oh, you are? Okay,
Yes.
great. Mr. Swazo, what's the likelihood of that case going to hearing?
This is the one on 527, correct?
No, this is the one on 513, I think. Right, Freya?
Correct. It's 25886 and 25887.
Perfect. Thank you.
Let me,
Sure.
Okay, so we do have those in the status conference docket today, and those were moved to 527.
yes, that's. my
Oh,
understanding.
okay.
So I am in
Right.
those cases as well.
Oh, so we're not worried.
I was confused. I was like, oh,
I'm sorry, Mrs. Swazo. Freya, would you take those off the, if they're not off that docket, will you take it off?
Okay.
So it sounds like we have Powderhorn is number 1, Ms. Hardy. It sounds like we have Select as number 2 and
Correct.
Chevron is number 3.
Right.
Okay, very good. Okay, so with that in mind, I know you wanted an expedited decision. I've read your motion several times. I've researched your motion. I'm really just waiting for the benefit of Ms. Bennett's. Will it be your response or will it be Mr. DeBrien's response?
It will be both of our
Both of
response.
you. Okay. I'm halfway there, and I'll get a decision to you rapidly once I get it'll be before Friday of that week. So if that helps you, great.
That does help. Thank you.
Okay. Ms. Bennett, anything further on that?
Nothing further. Thank
All
you.
right, thank you, Ms. Bennett. Ms. Hardy, anything further on that case?
No, thank you.
Thank you, everyone, for helping me through that. Let's call the first case on our list. This is Spur Energy Partners 25727.
Dana Hardy on behalf of Spur Energy Partners.
You?
Mr. Examiner Ernest Padilla for EML 210 Trust, GLJ 210 Trust, JLM 210 Trust, and EMC Oil and Gas Ltd. And
Good morning. Good morning, Mr. Padilla. What is your position on this case?
we don't have one anymore.
Okay.
We're done.
And thank you, Mr. Padilla. And it's good to see you. Ms. Hardy, you have some exhibits to admit?
Yes, we submitted our exhibits. We have the statement of our landman Drew Oldus, geologist Matthew Van Wee, both of whom have previously testified, and we provided their standard pooling exhibits.
So, so have you revised your exhibit packet? What are you requesting that I admitted to evidence?
So this case was continued to this docket. So we hadn't presented this case yet by affidavit.
You've not.
Right.
Were you curing notice in this case?
Yes.
Okay, very good. Then go right in. Let me just cut to the chase. We've reviewed your exhibits. It will be taken under advisement. So if that helps you get through this quicker,
Yes.
go for it.
Okay. Would you like me to just quickly summarize or no?
Quickly summarize.
Okay. Spurs seeks to pool uncommitted interest in the Yeso formation underlying a 120-acre standard horizontal unit comprised of the north half of the southeast quarter and the northeast quarter of the southwest quarter of Section 17, Township 17 South, Range 31 East in Eddy County, and will dedicate the unit to the Garrison 17 Fed wells. And our exhibits include the self-affirmed statements of landman Drew Oldis and geologist Matthew Van Wee, both of whom have previously testified before the division and been recognized as experts in their fields. Our notice information is included in Exhibit C and was timely provided to parties by certified mail last October. And then we timely published notice also last October. So that's the exhibits be admitted and that the case be taken under advisement.
Great. The exhibits are admitted without exception. I don't believe Mr. Padilla has an objection to any of the exhibits.
None here.
Thank you, sir. And the case is taken under advisement. So we're off the record in this case. Thank you. All right, let's move on to Mewbourne Oil. This is number 2 on our docket, 25746.
Dana Hardy on behalf of Mewbourne.
Thank you.
Good morning, everyone. Dina Bennett on behalf of Avant Operating 2 LLC.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley on behalf of Marathon Oil Permian, and we are just monitoring.
Thank you, Ms. Hatley. And Ms. Bennett, your position on this case?
Thank you. Avant Operating did object to this case proceeding by affidavit.
And what, I'm not going to ask, I don't think I'm going to ask any longer, why did you object? Because it's obvious why companies object to each other's proposals and applications. So how are negotiations going?
The negotiations are progressing and the parties, I mean, in coordination with Ms. Ms. Hardy, we had talked about potentially asking the division for another status conference, although Ms. Hardy looked back at the transcript for the case and saw that this was the final status conference.
Mhm.
So with that being said, she and I have conferred and we would like to request the furthest out contested hearing date, which I think is June 30th or June.
Yeah, June 30th is the furthest one out, yes.
And so that would be, in my understanding, our strong preference.
Okay. Hold on one second, let me make some notes. Ms. Hardy?
I agree with Ms. Bennett. The negotiations are proceeding and hopefully a contested hearing is unnecessary, but in the event it is, we would request late June.
I understand. Your intent, Ms. Bennett, is to file a competing application or not?
Not at the moment.
Not at the moment. Depends on how negotiations go?
Yes, yes. I mean, I
But
think
you may?
the negotiations are proceeding well.
Fine.
So unless the negotiations fall through, there wouldn't be a reason. And I don't want to cast any negative juju on the negotiations. So I'm just going to say that at the moment, no competing applications are on the horizon.
Reading a note here. So Freya, I'm not sure how the two messages either support each other or conflict with each other, or what the final resolution would that be?
This is for the Tap Rock cases?
Yes.
Yes, I believe that the motion to amend the pre-hearing order is still outstanding. It has not been addressed.
Okay, we'll go back to that in just a moment. Okay, so if negotiations do go south and you need to file your, you need to file a competing application, your comfortable with the deadlines for that?
We would not be able to file competing applications by June 30th because Avant would still need to propose, send out the proposal letters, and I'd still have to file the,
You haven't even proposed.
no. Mm-mm.
I didn't understand that.
Yeah. So that's why I know the division is disinclined to grant another status conference, but under these circumstances, we'd be setting an entirely hypothetical hearing date.
When was the case filed?
The case was filed in December.
It's been 5 months. And not only has it been 5 months, but you've had their proposal the month before. So it's really been half a year. Why would it take this long to either negotiate or decide to file a competing application?
The negotiations take some time. And if, like I said, the negotiations have been fruitful. And even at 2 status conferences ago, I mentioned to Ms. Hardy that Avant was under the impression that they had reached an agreement. So this isn't a delay on Avant's part. This is a normal back and forth, I guess, of negotiations. And so it's definitely not an Avant delay. So I wouldn't want the 6 months to be seen as any sort of prejudice towards Avant's position.
Right, but we'd be setting a contested hearing 6 months out from when the application was filed. So yeah, we'll issue a pre-hearing order for June 30th. And if the parties need more time, you can file a motion with an affidavit and I'll see what I'll do. But 6 months really is pushing the limit of our docket time. But there are extraordinary circumstances, and if you can show that. Okay, so anything further, Ms. Hardy?
No, thank you.
All right, thank you. Ms. Bennett.
Nothing further. Thank you.
Freya, what is the case number for the Tap Rock on the May 13? Or case numbers?
I believe it is 25886 and 25887.
Right, you said that before and I didn't write it down. Thank you. Let's go back to that case for a moment. This is your case, Ms. Hardy?
No.
This is
the-
Tap Rock's
Thank
case
you.
application.
Thank you.
Yes.
These cases are actually now next on our.
Oh, so I should have looked down. All right, thank you, Ms. Hardy. All right, so we'll get there. I'm now calling case number 3 and 4 on our docket, 25886 and 887.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, joined by my colleague, Dianza Valencia, appearing today on behalf of Tap Rock Operating.
It's good to see you here in person. Thank you.
And good morning again, Dana Hardy on behalf of COG Operating.
Thank you. And Ms. Hardy, before I go back to Mr. Suazo, have COG, I don't have this in front of me. Have you filed competing applications?
No, so COG objected and had planned to file competing applications, but the parties have negotiated, and it's my understanding that an agreement is being signed today.
Okay,
So,
okay,
yes,
okay. And that's your perspective is that
yes,
you're either very close or you've got an agreement.
yes,
Would that be an agreement in principle or an actual agreement?
an actual
An
agreement.
actual agreement. Mr. Suazo?
Yes, I can confirm. I was not aware that today might be the day, but I was aware that a letter agreement had been circulated and that it looked promising.
Okay. So then how do you want to proceed with your cases? Are you going to dismiss them?
If the agreement is signed, then yes,
Then you would dismiss them. Okay, and you have almost a month here
correct.
between now and then. Okay. And there was a motion to amend the pre-hearing order. Who filed it?
I had filed that motion because at that point, our witness, when we were still planning to proceed with the contested hearing, our witness wasn't available on May 13th. So we'd asked for it to be continued to May 27th.
Oh.
But at this point,
Right.
that's probably
Moot.
moot. Yeah.
Okay, let me take a look in our imaging system if I get access to it.
And if I could correct the
Yeah,
record,
please go
I don't know that we would dismiss, but it'd certainly proceed by affidavit.
I see. So you wouldn't force pool them,
Right.
COG, I see. Okay. I understand. So this is a motion filed by COG, approximately the 5th of this, no, the 2nd of this month. I see. Sure. And it was unopposed by you anyway.
Correct.
Okay.
Mr. Examiner,
Hold on one second. Let me just
Sure,
finish this.
sure.
So in February, at the end of February, you asked for a contested hearing. We set it for May 12, went to May 13. And Freya, that was was that on your, after we removed those other cases that moved? Oh, are these the cases that moved to May 20 something?
They didn't
Yes.
formally move that to that later date because the motion hasn't been ruled upon.
Okay, perfect. But these are the cases that were number 1 on your list originally?
Yes.
Perfect. Okay. All right. Well, thanks for helping us with our docket and, okay, great. So good luck. Good luck. And, let's see, I think the pre-hearing order, which is in front of me, says that if you do settle your differences with COG, that this will be heard. It's up in the front of it. June 4.
Okay.
So that's when you wouldn't have to, you would continue your cases if they're not already on June 4, if they're on May 13 now, you'd continue your case to June 4 and we'd hear them then.
Okay. That works.
All right. All right. Well, thank you both. If there's nothing further, we're off the record in Taprock operating. Let's move on to Matador production. There are several cases here, number 5 through 8 on our dockets, 2, 5, 9, 1, 2, 3, 4, and 5.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Greyhound Resources LLC and Matador Production Company. And I did have my hand up,
Oh,
if
sorry,
it
I
would
didn't see
be.
it.
No, that's okay. I did a little digging and I do actually have an update on that Powderhorn Quail Dobbs case.
you.
So if you want to go back to it at some point, I can give you an update.
Perfect. Thank you, Ms. Vance. We'll do that right after we finish these 4 cases.
Understood.
Good morning. Dina Bennett on behalf of Avant Operating 2 LLC, and Avant Operating 2 has objected to these cases proceeding by affidavit.
And what is your intent? Is it to file competing applications or just?
The intent is to negotiate with MRC, but at this point, Ms. Vance and I were coordinating this morning, and it looks like this one also was set for a final status conference for today. And again, Avant and MRC, I'm not trying to speak for Ms. Vance, I'm sure she'll weigh in if I'm wrong, but would appreciate the opportunity to have another status conference instead of setting these cases for contested hearing. But if the division is inclined to set them for a contested hearing, then it would need to be in early July because Avant would need to send out its proposal letters and file its applications. So Avant's strong preference is to hope that there's room for negotiation, but if not, then given timing constraints, I would need through the beginning of July for the first 10 days in July, really, for a contested hearing.
And do you have any idea how negotiations are going?
In Avant's view, they're progressing, but I think Avant has not heard from MRC recently. And so that's what's causing the stalemate and why Avant is now having to decide what to do. And its decision, if we have to go to a contested hearing, is to send out competing proposals.
And is this the basic issue here? Is this Avant doesn't like the proposed plan, or it's overlapping, or it interferes with Avant's operations in some way? What's the basic idea here?
I unfortunately don't have an answer to that because we were hopeful that we would not be in this place today.
Okay.
So I don't have that information.
All right. Thank you, Ms. Bennett. Ms. Vance?
I concur with Ms. Bennett. Matador has a strong preference to do another status conference with the hopes that the parties can reach an agreement and don't feel it's necessary at this point to set a contested hearing. But again, to Ms. Bennett's point, if we did have to set one, our strong preference would be for the latest possible date. And if it requires it to be pushed into July, that's not a problem for Matador. That way, Avant could perfect its proposal, timeframe, and notice. So.
Okay, and do you have information regarding the question about how negotiations are going?
I would concur with Ms. Bennett. I think Matador is, there was some initial negotiations and for whatever reason, maybe there was a little pause on it, but I believe that our landman should be reaching out to their folks and pick those negotiations back up.
When was 259112 filed?
2/5, so February 5th. Or it was filed I believe it was filed on February 5th.
Can you check for me?
Yes, absolutely. Give me just
Sure.
one. Yes, so it was filed on January 7th for the February 5th docket.
Okay, so it was filed January 7th.
Yes.
All right. So if I set an early July, I mean, that the reason why this was a final status conference is it's been 5 months now since this was filed, and we're still sort of hearing about negotiations, and it's on our docket. So I haven't heard a good reason not to set it, and I'll abide by the party's request to set it as far out as I can, but July means it's now 7 months on our docket, which is longer than I would like. Freya, do we have anything in early July?
Our special docket dates are July 7th and July 28th.
All right, July 7th, 7/7. All right. So Ms. Vance, Ms. Bennett, we'll send out a pre-hearing order for these cases for July 7, giving Ms. Bennett time to file her cases, if need be.
Thank you.
All right. Ms. Vance, let's go back now to what we were talking about. What case number do you want to talk about?
Okay, so for Ms. Hardy, it's the Powderhorn Quail Daubs, which is 25888. And then we filed a entry of appearance and objection on behalf of MRC Delaware Resources and Matador Production Company. And we just filed our competing applications, and I do have case numbers for those.
Okay.
So we'll be filing a motion to amend the pre-hearing order and add our cases to that. And I can give you those case numbers and Ms. Hardy those case numbers.
Please.
It's 26096 through 26098. And I believe Ms. Luck, she has entered an appearance in those cases on behalf of Waterloo.
So Ms. Hardy, you have one case, is that right? 25888?
That's correct.
And Ms. Vance, why do you have 3 cases?
That's a great question. I'll be honest, I have not been the one managing these. I just know that we filed those 3 and that they are supposed to compete with the Quail Daubs. So that's what I have. I'd have to look at the applications.
Have you, Ms. Hardy, have you seen these cases?
I have not seen them, but I have sort of a summary of them. And I think there are different spacing units proposed. I think MRCs have depth severances and Powderhorns does not.
Okay.
So I think that's part of the reason for the different number of applications.
Let me look at something here and then I'll hear from Miss Luck. Freya, are these cases number 1 on our docket?
Let me go back and check now
Thank
that
you.
Tap Rock may be going away.
I would think it is going away.
It's number 2. So number 1.
So it would be number 1. All right, very good. All right. Ms. Vance, is that what you wanted to let me know?
Yes, I just wanted to give you an update that we did file our competing applications and to Miss Hardy's point, I just did a quick cursory look and that's correct. There's depth severances with our cases and that's why we've got 3 of them. And just wanted to let you know that we'll be filing a motion to amend the pre-hearing order to add our cases to that May 12th contested hearing date.
All right. Instead of filing a motion, would you just file a proposed order? You've already told me what, the reason is, and I'll grant it, obviously. So just
Okay.
file a proposed order and I'll add it and we'll amend our pre-hearing order. Unless there's an objection from Ms. Hardy.
No objection. Thank
Okay.
you.
And Ms. Luck, did you want to enter an appearance?
Yes, Mr. Hearing Examiner, I'm here for Waterloo Resources LLC and WR Non-Op 2 LLC, and they don't have an objection to Matador's cases. At this point in time, we're just observing.
So they don't have an objection to Matador's cases. What about to Taprock's cases or case?
To Powderhorn's case, yes, I think that we maintain our objection to Powderhorn's case.
Powderhorn, sorry. Okay. So you maintain an objection to Powderhorn. Are you negotiating with Powderhorn?
It's my understanding that we intend to withdraw the objection to Powderhorn's case and just simply monitor these proceedings, but I have not yet gotten final confirmation from my client on that yet.
All right, but you'll file a written withdrawal when you do?
Yes, Mr. Hearing Examiner.
All right. And Ms. Hardy, were you aware of the objection?
Yes.
You were.
And in addition, EOG had entered an appearance in this case and objected to Powderhorn's application.
Do we have Ms. Kessler?
I
That
think
was that
Mr.
by Ms.
Examiner,
Kessler?
yes.
Oh, there
you hear me?
she is. I can, yes. Would you like to enter an appearance?
Thank you, Mr. Examiner. This is Jordan Kessler on behalf of EOG. See that my camera is messed up. There we are.
And did you want to tell me your position on this case?
Yes, Mr. Examiner, we maintain our objection for now. I believe that we're in discussions with Powderhorn.
Okay, thank you, Ms. Kessler. If there is a contested hearing, which it looks like there is, are you going to appear?
We would appear, I believe that we would offer limited evidence relevant to existing well bores.
Okay, thank you. Ms. Hardy, anything?
No, thank you.
Not on that. Okay, very good. Thank you, Ms. Kessler, Ms. Luck, Ms. Vance. So we're off the record in 25888. Let's move on now to Avant Operating. This is 25996. It looks like it's consolidated with some other cases that are maybe, I don't see them on our docket, but I'll call them anyway. 26062, 63, 64, and 65.
Good morning, Mr. Hearing Examiner. Caitlin Locke appearing for Avant Operating in this case.
Thank you.
Good morning, Mr. Examiner. Chris Harris, appearing on behalf of Coterra Energy Operating.
Mr. Harris, is this your first time appearing?
Yes, Mr. Examiner.
Okay, great. What firm are you with?
With Holiday Energy Law Group.
Oh, Holiday. Ben Holiday
Yes. Yes,
in
Mr.
San
Examiner.
Antonio?
That's correct.
Okay, great. And you represent Coterra?
Correct.
is it your cases that are the 260, 62, 63, and 64, 65?
Yes, that's correct. Those were filed in late March and they were set for status conference in May, but we agreed to move the status conference up to get the ball rolling on this.
I'm sorry, I didn't understand what you just said. Will you repeat it?
Those were filed March 26th, those cases, so the competing applications. And we were set for status conference in May, but agreed to move it up to this status conference to get the ball rolling on it.
I see. That's what you're saying. Okay. So before I go back to Ms. Luck, since you also, now your cases, Freya, when it comes to notice, which docket are those cases noticed on?
I believe since they're on the May status conference docket, they're probably noticed for the May hearing by affidavit docket.
I see. Which is what date?
That is May 7.
7. Okay. So your cases, Mr. Harris, would normally be on the May 7 hearing by affidavit docket, but we're hearing them today. That's interesting. I didn't know we could do that. I guess they're not they're not really on the docket today. They're really just competing with Miss Luck's case. Okay, I understand what's going on now. I'm caught up with everyone. Mr. Harris, how are negotiations going?
It's my understanding that negotiations are ongoing, but we've agreed to go ahead and set it for hearing at this time.
Okay. Do you have it before I go to Miss Luck? I mean, she had the original case, so I'm going to give her preference. Did you and Miss Luck agree on a date?
I believe we've agreed on July 28th is the date.
I didn't know that we offered July 28th. Did we offer July 28th, Freya?
We didn't formally offer it. However, the parties did reach out to me to state that they were unavailable in June and asked for what the July dates would be.
Perfect. And you gave them July 28th?
As, yes, one of two options.
Okay, perfect. Miss Luck.
Thank you, Mr. Hearing Examiner. I also want to let the division know that Avant has filed 2 additional applications that will be set for this contested hearing as well. I filed those yesterday, so those are for the 3rd Bone Spring and for the Cisco formations. They have not yet been assigned case numbers. But yes, I did speak with Mr. Holliday before this hearing started, and we agreed to the July 28th docket date since he and I are both unavailable on the June dates.
Okay. Ms. Chance, do you see those filings in the queue?
I need to look.
It was late yesterday, so it was probably close to 5 o'clock when they got filed.
All right, thank you, Ms. Luck. What I'd like to do is get those case numbers from Ms. Chance and then issue a pre-hearing order with these new Coterra cases, these 4 Coterra cases, and then you're going to have 3 in total Avant cases?
That's correct.
All right. Do you see them, Ms. Chance?
I do see them. I can approve them really quick.
Oh, you don't have to now. As long as we add them to the pre-hearing order, that's all I really care about.
Okay, I can't provide case numbers yet then.
Okay.
Okay.
That's not a problem.
Okay.
We understand. All right, so July 28, Mr. Harris, anything further?
No, Mr. Zimmer.
All right, and if we do have a contested hearing, you're going to be the attorney representing Coterra?
My partner, Ben Holliday, will be representing Coterra.
Okay, all right, very good. Okay, Ms. Luck, anything further?
No, thank you. I appreciate your time.
All right, thank you. All right, we're off the record in those cases. Let's move on to Matador Production. There are 3 cases, 10 through 12 on our docket, 26005, 6, and 8.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company and Matador Production Company.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC, and Avant has objected to these cases moving forward by affidavit.
And your intention, is it to file competing applications?
At the moment, Avant's objection is based on the fact that Avant has not received proposal letters for these wells. And so thinks that these cases were prematurely filed. But Avant, I coordinated with Ms. Vance this morning about that, and Avant's preference is to hopefully have the cases go away. But in the absence of that, we'd like to request, I'm not requesting another status conference, but I know that Ms. Vance is going to request another status conference, and I am not going to object to that. But that is the basis. Wow, this is so long. The basis of Avant's objection is that they have not received a proposal letter.
Okay, Ms. Vance?
So yes, I would concur regarding requesting for another status conference. These were filed on 2/24 and were filed for the March 26 hearing docket. And I did check, if there was any feedback from the division on whether or not we could ask for another status conference. Didn't seem like there was anything that would oppose that. So we would just ask for another status conference, and hopefully the parties can work out any kind of issues that they have.
And the idea that your client did not send out proposals to
I'm
to
sorry.
Ms. Bennett's client?
Yeah, Matador is looking into that. And at this point, I don't have an update. But again, we would just ask for another status conference and hopefully the issues can be resolved.
Okay. How difficult can it be to send out a proposal to Avant?
Well, I think that there's a question of whether or not they need to. And Matador's looking into that right now.
Okay. Okay. I find this amazing. Really, I find this amazing. Whether they should or shouldn't, I can't imagine that it's that hard to send a proposal to Avant, but okay. Sure, we'll give you one more status conference on these, but at that time, we're going to set a hearing for them.
Understood.
Okay, and that'll be next month, the status conference docket. Freya, what is it?
21.
May 21.
And Mr. Examiner, and just in case it's not clear, if it turns out that Matador hasn't sent a proposal letter to Avant, which is what is the actual scenario at the moment,
Right.
I'm reserving the right to file a motion to dismiss in advance of that second status conference.
I understand.
Thank you.
I get it. Okay, so Ms. Vance, anything further?
No.
Okay, and Ms. Bennett?
Nothing further. Thank you.
Very good. Let's move on to Oxy USA. We have two cases, 26009, 26010.
Good morning, Mr. Examiner. Dal Mullenberg of Santa Fe Office of Gallagher and Kennedy on behalf of Oxy USA.
Mr. Ken.
Good morning, Mr. Examiner. Dina Bennett on behalf of Chevron USA, and Chevron has objected to these cases moving forward by affidavit.
I meant good morning, Mr. Mullenberg. Mr. Kennedy, it's stuck in my head. Okay, and your position is what now?
We're objecting to the cases moving forward by affidavit.
Okay, and your intent is what?
At the moment, Chevron is going to be sending out competing proposals. The Oxy cases overlap acreage that Chevron owns 95% of in two sections. And so Chevron is intending to send out competing proposals and then file competing applications. And, just given timing constraints, again, it sounds to me like if Oxy is intent on moving forward with a contested hearing, that the earliest that could be is early July.
Okay.
But I'm hopeful that the parties will be able to reach a resolution given Chevron's large ownership.
That makes sense. Okay, so Mr. Mullenberg.
Thank you, Mr. Examiner. Oxy's interest is in proceeding to a contested hearing and getting that set as quickly as possible. We understand Chevron's position. It's possible that the parties might be able to work something out, but at this point in time, I don't think there's any way of knowing where that might go. So we would like to get this set for a contested hearing.
So first of all, on my worksheet, I have miscellaneous. I'm not sure why I have miscellaneous. Is this an injection case?
No, I'm not exactly sure why it would say miscellaneous either. They are non-standard. It's a large spacing unit.
Yes.
They're the two applications. I think they're both 1,920 acre spacing units.
But are you asking for compulsory pooling?
Yes.
Oh, you are. Freya, why is this listed as miscellaneous? Is that something that the applicant selected incorrectly or?
Correct.
Oh, okay. Can you change it?
I can.
Oh, excellent. I know that we're having the applicants do a lot more work now, entering cases, and maybe it's a paralegal or someone who is not familiar with.
Probably so. I've got a new assistant and she's not that familiar with the with the menu, so that's probably what's going on. But yeah, I don't recall any reason why this would be set for as identified as miscellaneous.
I know that we have, is it, Freya, do we have some sort of guide out there for people who are entering data now?
We do not.
We do not? Oh, we don't?
Not yet.
I thought that was part of the new guidance that we were releasing, but I guess not. Okay, but Mr. Molenberg, you can always ask your assistant to contact Freya. She's always willing to help. She used to do this entry herself, so she's very familiar with it.
Understood. And in fact, that's what I like to do, but we're learning.
Right. Okay. Sounds
as
good.
we go here.
And you filed your case, Mr. Molenberg, when?
Late February.
Late February. Okay. Does July work for you?
Yes.
Okay. Then we'll issue a pre-hearing order for July 7. It'll be a trailing docket. This would be the second case on the docket. And Ms. Bennett, that should give you time to file competing applications, plenty of time.
Yes, it does.
Yeah.
Thank you. And before this morning, we didn't know what the dates were for the July docket. So I would like to have the opportunity just to confirm that the 7th works, but I did confirm with Chevron that it would be sometime the first 10 days of July. So that should work.
Okay, very good.
Thank you very much.
Okay.
And Mr. Examiner, same
Yes.
for Oxy. We'll check on that
course.
date, but it works for me. So.
Okay, perfect.
Okay,
Well,
thank you.
excellent. Thank you both. We're
Thank
off the
you.
record in those two cases. We'll move on to what looks like our last case. It's Paloma Permian, 26025.
Sharon Shaheen for Paloma Permian.
And congratulations on your new independence, Ms. Shaheen.
Thank you.
You're welcome.
Good morning, Carrie Hatley representing COG Operating, Concho Oil and Gas, and Mongoose Minerals, and we have objected to these cases moving forward.
Okay, thank you.
Jackie McLean with Harding McLean on behalf of Vatex.
Thank you.
Mr.
What's your
Examiner.
position?
We are just monitoring.
Oh, you're monitoring. I just wanted to make sure what your position is before I moved on. So just monitoring. Okay, I'm sorry, Mr. Suazo.
Oh, Mr. Everhart.
Mr. Everhart, excuse me.
Yes, sir. With Beatty Wozak, New Mexico, appearing on behalf of Coterra Energy Operating and its affiliates, and we are objecting to this application moving forward by affidavit.
Okay, so we have an objection from Coterra. We have an objection from COG Concho Mongoose. Is that right? Okay, good. Let's start with you, Mr. Everhart, because you're in front of me now.
Okay.
What's your intent? Do you intend to file competing applications or just question witnesses at a hearing? What's your intent?
Yeah, thank you for the question, Mr. Examiner. So we have reviewed both Paloma's and COG's development proposals, and it's Coterra's position that we intend to support COG's forthcoming counter applications as their proposed development plan more fully aligns with Coterra's. But in the meantime, I think we would preserve rights.
Okay. And Ms. Hatley?
We are prepared to file competing applications. However, we're also having a lot of communications with Paloma, and I'm hopeful we may be able to work a trade or work a deal. So we would very much like one additional status conference if possible to keep working.
Okay, I understand. Ms. Shaheen?
Yes, I've conferred with Ms. Hadley and we agree that status conference, second docket in May would be preferable.
Okay, that'll be a final status conference, Ms. Shaheen.
Thank you.
All right, so that it will be moved continued by Paloma to the May 21st for a final status conference. All right, that's the last case on my worksheet. Is there anything else? Not hearing anything? We're off the record. Thank you.
Yes, Mr. Hearing Examiner.
Yes, Ms. Vance.
I caught you.
You did.
And I think you knew I was gonna try to
No,
talk
I
to
didn't
you.
actually. No, I didn't. But there you are. What can I do for you?
I just wanted to see if we could discuss very briefly. There's a contested hearing set on May 28th between Uburn Oil Company and WPX.
Hold on one second. Hold
Sure.
on. Let me pull up that. I don't know what you're talking about yet, but I'm going to get there. May 28, you said, didn't you?
That's correct.
May 28. Oh, that's the case that Freya mentioned to me this morning. I think it's the only case on that. It's the only set of cases on that docket. Is that right?
That's correct.
Okay. Now, do we have anyone from Uborn with us? Or are you?
I'm Uburn, and I believe Mr. Savage should be on the line. He said he was going to hang out, and he is representing WPX. There he is.
Mr. Savage, would you enter an appearance?
Yes, good morning. Thank you. Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shield appearing on behalf of WPX Energy Permian LLC.
Okay, thank you, Mr. Savage. And I'm assuming your cases are more recent than Ms. Vance's cases.
Yes, we filed those cases subsequent to Ms. Vance's cases.
Okay, and before I go back to Ms. Vance, what do you want to tell me about these cases?
Oh, well, I can tell you, and Ms. Vance can I believe can confirm that the parties have reached, the competing parties have reached a final agreement.
Oh.
And it looks like that it's going to go through. They just need some additional time, and I believe they're looking at 60 days that would allow them to finalize and close on the trade.
Okay.
So it seems like it would be very helpful. It seems like it'd be a burden to go through on both the parties and the division to go through a contested hearing, and then for the parties, because they're so close to closing, actually closing. Okay. While the division is evaluating. So anyways, that's my thought on it. Yeah.
So what you're saying is you would like 60 days out from today before these cases are heard, if they're heard at all. Ms. Vance?
I concur with that.
Right.
And what Mr. Savage said.
Okay.
We're very close to executing the agreement. We just need additional time and hopefully take the burden off of the division's plate and the party's plate.
You're always thinking of the division. That warms my heart. Okay, so I think what we can do is we can reset these cases for Freya, did we discuss June 23rd?
I think you suggested June 18th, which is the status conference.
Yes. Okay. Thank you.
We do have a special docket on the 23rd.
I remember that as well. That'll give you 60 days plus 2, Mr. Savage and Ms. Vance. If we reset these to the 18th of June, I need a motion and a proposed order. Okay. I don't need an affidavit here because I'm relying on your representations under your ethical duty of candor to the forum, which I know you hold sacrosanct. So if you'll file that, I will issue that order.
Mr. Hearing Examiner, really quickly, Ms. Hardy and I are both in these cases as well.
You are? I didn't know that.
Yes.
Hold on a second. We have some more voices here. Go right ahead.
Thank you. Dana Hardy on behalf of Permian Resources, and we are just monitoring these cases.
Thank you.
Good morning, Dina Bennett on behalf of Palomia Permian, and we did object to the cases, as I recall, but for preservation purposes only.
You objected for preservation? I've never heard that before.
Well, to preserve our rights to ask questions at the hearing and to
I get it.
That's not an intent to file competing applications, but to preserve the right to participate in a contested hearing.
So if the parties have come to an agreement, what happens to your objection?
Well, I did not know until this morning that the parties in air quotes had come to an agreement. But I don't think that Paloma intends to stand in the way of any agreement. I just haven't had a chance, obviously, to confer with Paloma about this, and I'm not entering any objection to the resolution that the parties in air quotes have suggested today. I just need to confirm with Paloma, but assuming that they reach an agreement there, that's would in theory dispose of Paloma's objection.
Okay, and so you have no objection to my resetting this for June 18th?
No.
I didn't think so. All right. Okay, is there anything else, Ms. Vance and Mr. Savage?
No.
Oh, thank you.
Okay, so who will file the motion and the, I'm sorry, not the motion, but the proposed order? Will it be you, Ms. Vance?
Yes, and I will tell you, I'm on military duty right now,
Ah,
so
okay.
I may not file it until early next week, if that's okay with the division.
Are you taking part in the naval blockade in the Red Sea?
No, I am not.
Ah, well, I was going to wish you good luck.
Thank you. No, I am in Oakland, California right now.
Oh, okay. You're not even close. All right. All right. So you'll coordinate with Mr. Savage on the proposed order?
Yes, I will.
All right. Very good. Well, thank you very much. We're in recess on those cases, and I assume there's nothing else today. Not hearing anything. We're off the record. Thank you.